Hello everyone, this is your host Syed Amir Hussain. Welcome to Courts Today by Livelaw, your one-step destination to all legal developments in the country. Starting with an update in the Bilkis Bano case, the Supreme Court today refused to entertain a plea filed by two convicts challenging the January 8th judgment which set aside their remission granted by the Gujarat government and directed them to surrender. A bench of Justice Sanjeev Khanna and Justice Sanjay Kumar heard the matter and ultimately dismissed the plea as withdrawn, while expressing that it cannot sit in appeal over a judgment rendered by a coordinate or co-equal bench. Under Article 32, we are not sitting in appeal. How is this maintainable? It's misconceived, said Justice Khanna. To recap briefly, on January 8th, the Supreme Court set aside the remission of 11 convicts sentenced to life imprisonment for multiple murders and gang rapes, including that of Bilkis Bano during the 2002 communal riots in Gujarat. It was held that the state of Gujarat was not the appropriate government to decide the issue of remission as the trial was held in the state of Maharashtra. Since the Gujarat government was found to be incompetent, the remission orders were held to be invalid. Accordingly, the court directed the convicts, who were given premature release in August 2022, to surrender in prison within 2 weeks. In other important news, the Supreme Court will consider the plea for setting up a special investigation team, that is SIT, to look into the alleged quid pro quo arrangements under the Electoral bond scheme on Monday, along with other similar petitions. Advocate Prashant Bhushan brought up the matter before the bench led by CJI D.Y. Chandrachud. The main petition filed in April seeks the constitution of a special investigation team to investigate the alleged instances of quid pro quo arrangements between corporations and political parties through electoral bond donations. The development comes as an aftermath of the top court's decision to strike down the electoral bond scheme as unconstitutional and violative of Article 19, Clause 1A of the Constitution. The petition filed by NGOs Common Cause and the Center for Public Interest Litigation alleges that a scam worth crores of rupees is involved in the electoral bonds matter. The petitions will now be heard on Monday, July 22nd. Now coming to the issue of NEET-SS, that is NEET super speciality, the Supreme Court today on July 19th issued notice on a petition challenging the decision of the National Medical Commission, that is NMC, to not hold the NEET super speciality exam for 2024. The petition was filed by 13 doctors under Article 32 of the Constitution. The bench of CJI D.Y. Chandrachud and Justices J.B. Pardiwala and Manoj Misra noted that due to this decision of the NMC, there would not be NEET-SS exam for students this year at all. The court issued notice to the Union Government, the Medical Counselling Committee and the NMC. It also allowed the petitioner to add the National Board of Examination as a party respondent. Initially, the CJI asked why the petitioner had approached directly to the top court under Article 32 petition. The council explained that the exam is conducted annually according to a fixed timeline as per the previous Supreme Court judgment in Ashish Ranjan versus Union of India. In Ashish Ranjan, the court had laid down a timeline schedule to be followed for completing admissions to medical colleges. The matter will now be heard on July 26th. In news about the new criminal laws, the Madras High Court today wondered what prompted the central government to repeal the erstwhile criminal laws of IPC, CRPC and the Evidence Act when any proposed changes could have been incorporated by way of amendments to those acts. While hearing 3 PILs filed by DMK Organizing Secretary R.S. Bharati challenging the constitutional validity of the BNS, BNSS and BSA, a division bench headed by Justice S.S. Sundar orally remarked, "Why did you want to change everything? Was it to confuse people? You could have made small amendments." The bench, also comprising Justice N. Senthil Kumar, recollected that when the CPC was amended, there was a huge cry and many judgments were passed giving interpretation of the law. It thus apprehended that the new laws will bring confusion and will require interpretations, in effect causing more delays in the judicial system. The Supreme Court recently reiterated that the purpose of making check bounce an offence was to ensure reliability of checks and compensatory aspect of remedy under the Negotiable Instruments Act 1881 has priority over the punitive aspect in such cases. A bench of Justice Sudhanshu Dhulia and Justice Ehsanuddin Amanullah observed that courts should encourage settlement in check dishonor cases. The court referred to its earlier decision in Raj Reddy Kalyam versus State of Haryana and others, where it quashed a conviction despite the complainant refusing to give consent, observing that the accused had sufficiently compensated the complainant. The court set aside the conviction of Messrs. New Win Export and its partner P. Kumarswamy, the appellants, in a check bounce case following settlement between the parties. The case arose from a complaint filed under Section 138 of the NI Act by A. Subramania, the respondent. In important news about the West Bengal governor matter, the Supreme Court today on July 19th sought the assistance of the Attorney General of India in a petition filed by former women employee of the West Bengal Raj Bhavan challenging the immunity claimed by the state's governor C.V. Anand Bose against the investigation in the molestation complaint levelled by the woman against the governor. The petitioner contended that the immunity granted to the governors from criminal proceedings as per Article 361 of the Constitution cannot bar investigation. The bench, comprising Chief Justice of India D.Y. Chandrachud, Justices J.B. Pardewala and Manoj Misra, granted liberty to the petitioner to implead the Union of India in the petition filed under Article 32 of the Constitution. It can also be noted that C.V. Anand Bose, the governor, has moved the Calcutta High Court for defamation against the West Bengal Chief Minister Mamata Banerjee concerning the molestation allegations. Recently, the High Court restrained Mamata Banerjee from making defamatory comments against the governor. In the next update, the Bombay High Court has held that Maharashtra government's decision exempting private unaided schools from providing 25% quota in class 1 or preschool for children of disadvantaged sections if there is a government-run or aided school within 1 kilometer radius of that private school is unconstitutional. The decision was taken by the state this year by amending the Maharashtra Right of Children to Free and Compulsory Education Rules 2011. A division bench of Chief Justice Devendra Upadhyay and Justice Amit Borkar set aside the rules as unconstitutional and ultra-vires to the Right of Children to Free and Compulsory Education Act 2009, that is the RTE Act. The Supreme Court held that if any dispute arises as to whether a contract has been discharged or not, such a dispute is arbitrable. Once the contract has been discharged by performance, neither any right to seek performance nor any obligation to perform remains under it. However, whether there has been a discharge of contract or not is a mixed question of law and fact. And if any dispute arises as to whether a contract has been discharged or not, such a dispute is arbitrable as per the mechanism prescribed under the arbitration agreement contained in the underlying contract, the court said. Taking cue from the judgment of National Insurance Company Limited versus Boghra Polyfab, the court said that when the parties to a contract were not ad idem over the full and final settlement of the contract, then mere execution of a full and final settlement of a contract would not by itself operate as a bar to arbitration when the validity of such full and final settlement of a contract was itself in question. In a case raising the question as to whether a bar association's election are amendable to writ jurisdiction of constitutional courts under Article 226 of the Constitution, the Supreme Court today expressed that if there is an issue regarding the elections to a bar association, the same shall go before the concerned civil court. The bench of Justices Abhay S. Oak and A.G. Masi was dealing with, in particular, with the case of Alipur Bar Association when it disposed of the plea as withdrawn, leaving the question of law open. To recapitulate the facts of the case, petitioner Subir Sen Gupta filed a writ petition before the Calcutta High Court raising issues pertaining to the elections of Alipur Bar Association. He contended inter alia that names of almost 400 members of the association were included in the final voter list, even though they had not cleared the AIBE. The High Court disposed of this petition, setting aside the election notice and directing the Bar Council of West Bengal to take a call on whether such persons who had not cleared AIBE were eligible to cast vote in elections of the Bar Association. To know more about this case, do check out our website at www.livelaw.in. In another update coming from the Bombay High Court, the court held that a husband convicted for causing the dowry death of his wife stands disqualified from inheriting the property of the deceased wife as provided under Section 25 of the Hindu Succession Act. Single Judge Justice Nijamuddin Jamdar rejected the argument of the Testamentary Department, which opined that a person convicted for causing dowry death under Section 304B of the IPC cannot be equated with the murder as prescribed under Section 25 of the Hindu Succession Act, as the law only disqualifies a person convicted for murder under Section 302 of the IPC. The court emphasized that Section 25 of the Act disqualified a person who commits murder or abets the commission of murder. This expression, it said, must be construed as to advance the object of the Act, which is to disallow devolution of property upon deceased's murder. The Supreme Court, while granting bail to a man accused under the Unlawful Activities Prevention Act 1967, that is UAPA, observed that the judgment in the case of NIA versus Zahoor Ahmad Shah Watali cannot be cited as a precedent to deny bail in UAPA cases where the accused has suffered long incarceration. The court noted that in Watali case, the bail granted by the High Court was set aside due to the specific facts of the case, wherein the High Court conducted a mini trial to overturn the trial court's prima facie findings against the grant of bail. In the present case, the Supreme Court, taking note of the 9-year period of under-trial custody and slow pace of trial, chose of granting bail to the accused following the precedent in the K.A. Najib case. The bench, comprising Justice J.B. Pardiwala and Justice Ujjal Bhuyan, set aside the order of the Allahabad High Court, which had denied bail to the appellant. Giving a possible interpretation of Section 531, Clause 2A of the Bharatiya Nagarik Suraksha Samhita 2023, the Delhi High Court said that only if an appeal is pending before the new law came into force, such an appeal can be continued under the CRPC. Justice Anup Jairam Bambani said, as per the general settled principle of law, an appeal is considered to be a continuation of the trial. However, the wording of Section 531, Clause 2A of the BNSS is amenable to a possible interpretation that if an appeal is pending before the coming into force of the BNSS, only then would such an appeal be continued under the CRPC. Meaning thereby, if an appeal is filed after enforcement of the new criminal laws, it will be governed by the provision of the BNSS, even if the trial of such case was conducted under CRPC. However, the court has not decided the issue fully and left it open to be considered subsequently. If you wish to know more details about the cases I mentioned here, you can visit our website at www.livelaw.in. Stay ahead with quick legal updates only on LiveLaw. Don't forget to like, share and subscribe and support us. You can also support us by donating through the thanks button at the bottom of our videos or consider becoming a member at just ₹89 per month.